Welcome back, everyone. We're now going to start the land rights panel. But before I do that, we have Shivani Chaudhary, who just joined us. She, I just wanted to introduce her. Okay. So just wanted to welcome Shivani as well. Of the interests of a state apparatus, which, due to its colonial nature, did not represent the people. How does such a post colonial state, which has many continuities with the colonial state, but which is now a democratic constitutional state and does to a great extent represent the people, how does such a state reshape property entitlements in land, both constitutionally and statutorily, in order to bring about development for all? This question is particularly important in the context of indigenous groups, or, or in India, what we call the scheduled tribes or Adivasi groups of people, who have been historically disadvantaged and marginalized by the colonial state. And these groups, despite protective legal frameworks in the Constitution, continue to be the most displaced and impoverished groups in India. So the question, there are many questions here, but first is it even possible to have development for all, or will there always be economic development of some at the expense of others? So the plan for this panel is that I'm going to speak about the Indian context, followed by Usha, and then Jackie and Dani, who will speak about the South African context, and then Frank will offer his thoughts and comments on what we say. So, to address this question in the Indian context, we find that there are two different legal regimes governing different groups of people in India. The first regime, which applies to the vast majority of the Indian population, pertains to individual property rights in land. The second regime pertains to group or community rights to property, and these rights are applicable to particular groups of people, like the Adivasi communities or scheduled tribes in the scheduled areas, or forest dwelling communities, which may overlap with the scheduled tribes or may include people who are not classified as Adivasi groups. There are also communities like cattle grazers, traditional fishermen, and other communities engaged in traditional occupations that have customary rights to common property resources, whether that of the sea or pastoral lands and so on. But I won't be talking about those customary rights here because of paucity of time. I'm only going to speak about those rights that have constitutional or statutory protection. It's not to say that they're not important, it's just that we can only talk about so much. Now, in any social system that recognizes private or community property, the state restricts property rights in the exercise of its sovereignty, exercise of powers inherent in its sovereignty. These powers are usually stipulated within the constitutional text. Broadly, these sovereign powers are classified as police powers, eminent domain, and taxation. Distinguishing between these powers becomes important because even though state action in the pursuance of them involves restrictions on existing property rights, the obligations on the part of the state in each instance are different. Police power, understood simply, is the power of promoting public welfare by restraining and regulating the use of liberty and property. The power of eminent domain, on the other hand, is the power of the sovereign to take away property for public welfare, whether individual or community property, without the owner's consent and upon payment of compensation. So first, speaking of the individual right to property in India, I would like to say that we find that it has really come full circle. It started out as a legal right against the state's power of eminent domain, which was enshrined in a series of colonial legislation, starting with the Bengal Regulation, the first of 1824, and culminating in the Land Acquisition Act of 1894, which act was in force until very recently. This right was later elevated to the status of an entrenched right by Section 299 of the Government of India Act of 1935. When the Constitution was adopted in 1950, the right to property was elevated to the status of fundamental constitutional right. And remember, here I'm talking about individual property rights, the first legal regime. So what we mean when it became a fundamental constitutional right was that the state could no longer legislatively remove the limitations imposed upon its power to acquire property, and the right was made judicially reviewable. However, through a series of constitutional amendments between 1950 and 1978, Parliament carved out exceptions to the fundamental right to property, as a result of which some of the limitations on the state's power to acquire property, specifically the requirement to pay market value compensation, was no longer applicable in particular cases that were carved out by those amendments. Finally, in 1978, the 44th Constitutional Amendment deprived the right to property of its fundamental right status, thereby making the limitations on the state's power to acquire property, uh, thereby easing the limitations on the state's power to acquire property. Um, you can say that it made it non-justiciable, but it's more complicated because there was a different provision inserted in the Constitution. And over the last decade especially, there have been attempts made judicially to restore the right to property within Article 300A in the way that it was at the time of the 44th Amendment. Also, recently, we have had the repeal and replacement of the 1894 Land Acquisition Act by a new act, the LARR Act of 2013, which has legislatively strengthened some of the requirements of the right to property against the state's power of eminent domain. However, within a year of this law's enactment, there have been attempts by the state, now through the thrice promulgated LARR Amendment Ordinance, to remove these protections. And yet, the inability of the government to garner parliamentary support to pass this amendment bill into law testifies to the intense social and political contestation around the contours of the individual right to property, both as a legal and constitutional right. Importantly, however, as we study the checkered trajectory of the individual right to property in the Constitution, as seen from the drafting of the original property clause before the Constituent Assembly and its evolution through judicial interpretation, legislation, and constitutional amendment, we see the state's continual attempts to reshape property relations in society to achieve its broader goals of economic development and social redistribution. Each iteration of the property clause, and this is important because one of the questions we have been collectively deliberating upon over the years is really how much does the constitutional text matter as opposed to other factors and other arrangements. And so this is important because what we find when we study these iterations of the property clause is that each one of them favored the rights of certain groups over others. So, for instance, the Section 299 of the Government of India Act was specifically enacted to safeguard the rights of zamindars or large land owners that had historically been loyal to the British. Now, the Constituent Assembly, on the other hand, in the drafting of the Property Clause, Article 31, weakened the rights of zamindars but retained protections which were mostly geared to protect the rights of industry. Now, these iterations of the Property Clause emerged as a product of intense contestation between competing groups within the overarching development discourse of the post-war world when the Indian Constitution was drafted. Following the adoption of the Constitution, what we find is that the groups that lost out in that contestation, namely the zamindars, used both the legislature and the judiciary to further their interests. But they succeeded to a certain extent and failed to others. But interestingly, now that I have completed a study of more than 200 Supreme Court cases decided on the right to property, I find that apart from the traditional elites, a large variety of people or traders, bus operators, importers, food sellers, religious institutions have used the property clause to safeguard their property and livelihood interests against state schemes of nationalization of road transport, restrictions on sale and export of goods, that in depriving them of their limited property interests also deprived them of their livelihood. So in many instances, the property clause has actually been used to protect the right to livelihood. So in some ways, once the property clause was created, it took on a life of its own. And an exhaustive study of the universe of property cases in India reveals that the traditional political narratives of the use of the property clause by only traditional landowning elites is simplistic and incomplete. In fact, as I have argued in our book, the rights of different groups often conflict with one another, so that despite the recognition of a social and economic right to housing in the late 80s and 90s, more poor have been evicted from their dwellings during this period than during the recognition of the right to property as a fundamental right. And in fact, there are very few cases where the right to property has been used to displace people. Especially when these evictions happen as a result of large-scale projects of economic development like dams, infrastructure, the courts have never prevented such evictions, whether during the regime when we had a property clause, a justiciable clause, or the right to housing. This appears counterintuitive, but it is not when we understand that in developing economies, courts are operating within the same development discourse as the government. And that brings me to the second question as to why, despite the constitutional recognition of the social economic right to land of the Adivasi groups, the scheduled tribes are the most displaced people in India. And here the statistics are absolutely appalling. 51%, that is more than half of all scheduled tribes, are below the poverty line. 65% of the scheduled tribes are landless, as per the 2011 census. And this number is not only high compared to the national average of 40%, but it's especially egregious because the scheduled tribes constitute only 8.6% of the total population, but they constitute 55% of the people who have been displaced since independence due to the construction of dams, mining, as Usha also talked about, industrial development, and the creation of wildlife parks and sanctuaries. Therefore, it is very clear that these groups have disproportionately borne the burden of economic development. And this is the case even though, as I said, the Indian Constitution, through the 5th and 6th schedules, contains special protections for the rights of these people. And even though individual property rights were weakened through successive amendments in the Constitution that I talked about, the 5th and 6th schedules have remained unchanged. Also in 1996, the Panchayat Extension to Scheduled Areas Act, and in 2006, the Forest Rights Act provided further statutory protections to the scheduled tribes. So why is it that why do we have this dismal scenario? And the preliminary answers that I've found based on the archival work we have done and field research in 3 states, one of which Usha referred to, the state of Andhra Pradesh, which has now been split into Andhra Pradesh and Telangana, and the state of Gujarat, which is where the riots happened. So based on our work in these 3 states, some preliminary thoughts, and I would love to hear your feedback, are as follows. First is that, the special protective provisions in the Constitution have to be seen against the backdrop of the broader framework of law and governance within which they operate. We have to look at the state's active role in displacing tribals from their land through various laws of land acquisition. And I'm also working on a separate study where we are analyzing all cases on land acquisition that have been decided by the Supreme Court. It's a database of 2,000 cases. And we have found so many laws of land acquisition that we didn't know exist. There are more than 100 laws of land acquisition, both at the state and the federal level, that have been used to displace people. Then we have other laws of mining. We have laws that protect forest land. Through a series of colonial legislation, the government declared large tracts of land with forest cover as land that was to be owned and managed by the state forest department. As a result, in one stroke, the state outlawed the rights of the tribals. And now we have the Forest Rights Act, which has sought to reverse the historic injustice and recognize the rights of tribals to this land, but it has happened 50 years since the constitutional framework was adopted. So when there are conflicting regimes, the regime which seeks to displace succeeds in India. Why? Because with respect to the 3 intersecting narratives of development, representation, and rights to land, the scheduled tribes are placed outside the dominant mainstream. The first narrative is that of development, that is, the special status of the scheduled tribes arises because their economic, political, and social way of life is considered not as developed as the rest of the population, and therefore they are identified as particularly vulnerable groups of people. This is different from, say, the scheduled castes, which is another vulnerable group in Indian society, but whose special status arises because of a narrative of systematic discrimination. So it's not development, but discrimination within the mainstream of Indian society. The scheduled tribes have always been outside the mainstream and have been keen to protect their identity as such. The second narrative is that of representation. The scheduled tribes are represented through a group identity within the constitutional framework, which is different from the rest of the population, the people who are sitting here, who have individual representation. And the third narrative is that of their relationship to land. They have both individual and community rights to land. But unlike the rights to land that I have with respect to land that I can own in Delhi, though I probably cannot afford it, until recently, the scheduled tribes did not have recognized individual and community rights to particular pieces of land. So their rights were organized within those areas, recognized within those areas, but not to particular pieces of land. As a result of which, they were particularly vulnerable to displacement by the state. So that's the second point I want to make, is that we need to view the efficacy of the protective provisions in light of the fact that in terms of all these 3 narratives, they are against the dominant mainstream. And that is one reason why some have suggested that in the last 65 years, even though the scheduled castes remain vulnerable, they have actually come out better than the scheduled tribes. Now, the FRA has been the Forest Rights Act has been a positive intervention, but there are continuous attempts to chip away at that by the opposing legal regimes and the opposing forces of development led by state and private industry, about which Usha also spoke about. Finally, the institutional apparatus for the implementation of the provisions of the 5th schedule is extremely important, because the debate as it happens in India happens mostly at the constitutional level or the statutory framework. But what we find is that the problems are, the many serious problems of implementation, and perhaps changes in the institutional framework would make things much better in terms of enforcing these rights. To give you an example, the Tribal Welfare Department has become the nodal agency for implementation of the Forest Rights Act. But because it is the Forest Department that has been running these areas for so many years, and which is particularly hostile to giving away control over that, we have found that not only are they uncooperative with the tribals, there is hostility and lack of coordination between the Tribal Welfare Department and the Forest Department. So to conclude, while the constitutional text certainly matters, what it really does is to set certain constraints for contestation between competing political groups. The fluidity of the constitutional text means that it is the overarching discursive narratives of which in developing countries, the economic development narrative is one of the most dominant that will determine which property entitlements are protected and which are sacrificed. Therefore, the efficacy of special constitutional protective provisions for vulnerable groups require threefold intervention. First, understanding in really just mapping the hundreds of laws that are there, understanding and reversing the competing legal regimes that chip away at those protections. Second, understanding the potential and limitations of the institutional apparatus that exists to implement those rights, both of which are continuities from the colonial state. I mean, we've basically continued our bureaucracy. And finally, resisting the dominance of a particular hegemonic narrative of economic development that prioritizes industry-led economic growth over everything else. Thank you. Usha?
It's a slightly different perspective. I know this is a discussion forum too, so I'll just state the perspective. The first thing is questioning this idea of sovereignty of the state as sovereign over land. I think that's a contested notion, and I don't think we need necessarily take that as a given. The doctrine of eminent domain, this is one of the ways in which we've been thinking about it here, that the doctrine of eminent domain is about private land being taken for a public purpose on payment of compensation. So these three elements have to be there for it to be, for it to be an exercise of the power of eminent domain. But very often we find that lands which are not private, which are either common land or what is very often in records called government land, gets diverted without, there's a change of user process, but it's like it's shrunk. Most procedures in relation to land have shrunk into nothingness. So they are just, it's just something that they have to do. They'll say, okay, we're inviting objections, you give your objections, and they put it on a shelf, and that's the end of the story, because there is no way by which you can hold them accountable for not, there is nothing particular that they are expected to do in the legal regime that's set out. So the takeover of government lands, and it's, when we were working on the Forest Rights Act, the way in which the forest rights and the forest areas are constituted goes back to the 1800s. And in the late 1800s, there are two people who were central to the way in which the Forest Department acted in the country. So one of them, Baden-Powell, has written this book, which is a manual for foresters. And it's for training them. And one of the things he says there is, how is it that in India so much of the land is government land? And you find that it has a historical context, because the idea of settlement and of the relationship between the colonial administration settling lands on classes of people who would then be asked to produce revenue out of it, that was the only context in which they were interested in settling and recognizing and handing over documents and making these large landlords and the feudal landlords, to make them have recognizable rights and therefore recognizable responsibilities to the state for producing revenue. Much of India, you'll find that it's not, you don't have documentary ownership of property. But there has been actual occupation, possession, use, and effectively, therefore, a right that they have over, various plots of land. What the Forest Rights Act did is very interesting, because, okay, I'll just give you a brief on what this is about and why I say that sovereignty is not such an unmediated and, it's not such an uncomplicated notion. First of all, the Indian Constitution says that the people are sovereign. So there's no question of state having sovereignty over a people. And I think, as you know, socioeconomic rights are political things, so we oughtn't to even to be accepting it, according to me. The second thing is that when in the Indian context, and I'm sure it applies in many other places, this idea of eminent domain is not flat. For instance, in the tribal areas which Namita was talking about, these are called fifth schedule areas and sixth schedule areas. And if you just take the fifth schedule areas, which is in mainland India, you find that there are restrictions on land alienation, where the transfer of land from a tribal to a non-tribal can't be easily done. So it's not like, it's not just that the people can't do it. It's also that the state can't hand over land from a tribal to a non-tribal. The state can take it over for its own purposes. The public purpose has to be served by the state. But alienating it and handing over tribal land to non-tribals. And when they say tribal land, they are not talking about individual ownership of land, but about territories which are considered scheduled areas. And therefore, in those areas, you can't have the transfer happening. So, even as it is, you find that it is not. And then you have the forest department. And that's a fascinating story. We're just writing it up, but, it's really like a very interesting story, because in the late 1800s, you have the state wants to have control over trees, and therefore forests, so that it can get the trees that it wants and the wood that it wants for the development projects that it had, like the railways. And so it starts reserving various blocks of forest, and says that nobody else can have any access to this. It creates a forest department which has to protect and manage that forest. And then at that time, they're still talking about commercial exploitation, which means that they have to take they can cut the tree and take it, but it has to be regenerative, because they're going to keep needing more and more wood. So that's the way they think about it then, which of course changes when when you just need the land and you need to cut it, you need to cut down all the trees, then the idea of continuity goes off. So, there is no intergenerationality after some time. But in the beginning, they talk about that. Then in 1927, we have a law which consolidates all the practices till then. And it says that there are reserved forests, there are protected forests, and there are village forests. And, for those who were born into a generation where reserved meant for conservation, and conservation was the big thing, you think that, okay, they're reserving these forests to conserve them. Oh, they were not. They were reserving these forests for the state. And the state would decide when it wanted, what it wanted from those forests. And the management and protection was for the state. And this, so when, the forest department was acting to manage and protect those interests for the state. Then and I'm jumping a lot, but by 1980, we have a Forest Conservation Act. By then, environment has become a big deal. You need trees, you need to have a certain territory being, 33%, they said then, which has to be covered by trees. So they bring in forest conservation. And for those of us who read the law and trust its word, we think that forest conservation is about conservation. But it's not about conservation, because it is actually about shifting the locus of decision-making about diversion of forests for a non-forest purpose from state governments to the central government. So the central government then takes over the power, and it says, we will do it at a national level. We are going to make, whatever decisions are good for the country as a whole. And so no state government can do it on its own. We will do it now. So it's only shifting the locus. Then we have this huge case that happens, which is continuing actually. Around 1995 it started, called the Godavarman Tirumulkpad case. They're called the forest cases. And the court then gets into it, and there are basic things like, what is a forest? Because if you go to the reserve forest area, you'll find that reserve forest area is something like 23% of the land mass. But you don't have more than 11%, now it's increased, but in the 80s it was about 11.5% was the tree cover on these. Then you say if reserve forest is 23%, you should at least have forests on 23% of the land. And you find, no, the reserve forest, the land, the land went with the forest. When the forest went, the land remained with the forest department. So there is nominally a forest, because it is reserved as a forest, but there is no forest there. So then the court has to figure out, now what do we do? Because then they say, okay, whatever in law is a forest, whatever in the dictionary is a forest is also a forest. So, anything with tree cover, whatever, that becomes a forest. And then in the way we had a third tier of government added in the early 90s. So we have the central government, the state government, and then panchayats and municipal corporations. In that, they say that these provisions in relating to panchayats and municipal corporations will not automatically apply in tribal areas, in scheduled areas, where there are tribals. It will have to be extended to those areas by a law that Parliament will make, which will modify, and with those modifications, it will apply in those areas. So then you have the law that Namita was referring to, which is the Panchayat Extension to Scheduled Areas Act, under which a certain amount of autonomy is given to the tribal communities to decide about, including whether they want a project to be located on their land or not. So that again takes away the nature of control over land. I'm just saying that sovereignty is an extremely, it doesn't exist. It is presumed, and that's why the importance of recognizing the difference between power and authority. It's by the use of power very often that they are bulldozing their way into these places. It's not because they have legal authority to do it. The law, in fact, says something else. And then in 2006, we have the Forest Rights Act. Now, the Forest Rights Act is very interesting because it's one law that recognizes three kinds of rights. One is individual rights. And I think, I actually think that this idea of individual rights is complex. It's not that simple. Because you give, the way they say it is you settle, in fact, every time World Bank comes in here and says, we will fund a forest project, they say, settle the rights of the people inside there, then we'll give you this. Because the moment you settle it, it is recognizable, definable, and therefore displaceable. Whereas when it is community, it is that much more difficult. It's not something that you can just do. So you have individual rights in this, then you have community rights, and you have habitat rights. So that's a set which has, now the problem is, and it says in the law that this is a historic injustice, and they do not talk about giving rights to forest dwellers, they say recognizing the rights of forest dwellers, which means that treating them as encroachers through all those years, and treating what they did in the forest as forest offenses through those years, was actually an injustice done to them, and it's an apology through a law, which means that they have to, but the problem is that a law that has lasted for so long creates habits. It creates not only habits of oppression, it also creates habits of submission. And till we recognize that this law has actually changed the nature of authority, changed the nature of autonomy of the local communities, this will not change. The attitude to the, so it's still like, in many groups who work in these areas, it is still as if there is a way in which you have to apply to the state. And the most fascinating example that we have in this is what happened where Vedanta wanted to locate a, they have their plant, aluminium plant in a place which is very close to a hill, where they want to mine for bauxite. And it's at the top of the hill, and they want to mine for bauxite. Now, it's a long story, so I won't tell you all of it. But just this, that we have tribal communities, and then we have what used to be called primitive tribal groups. And then they felt that that was pejorative, so they find particularly vulnerable tribal groups less pejorative. So that's the term that's used now. And so they belong to that, primitive tribal group of a particularly vulnerable tribal group. And what they've said after a whole exercise where they basically rejected the idea, they exercised their autonomy to say that we reject the idea of your coming here and mining. When the forest department went to tell them, okay, and the rural, the Dongria Kon tribal agency, when they went to them to tell them that, okay, we are coming here, development agency, when they said we are coming here to get your forest rights recorded, they said, we don't need you here. Who are you? And they sent them off because they said, we don't want any of your processes because we know where this is headed. You come to us only when you want to throw us away. So we don't want this. So there are ways and ways in which it's important to recognize the shift of control, the shift of authority, and the way in which power gets used. So that gets mediated. And one last thing, which is on, in socioeconomic legal studies, we have these two notions of poverty and impoverishment, which Professor Bakshi gave us. So poverty there is treated like it is a static concept, and impoverishment it's like it's something that is made to happen. So it is induced. It is not, it just doesn't exist on its own. And therefore, there's a process, and very often law plays a very strong role in making that impoverishment happen. But there is a third thing that we realized when we went in tribal communities, which is important given what Namita said about the tribals being poor. Actually, the idea of poverty in these areas is somewhat different, because the way in which we measure poverty or the absence of it is not how it works in many of these communities, where it is not about what you have, but what you can access. So when there is a fencing off that happens, either when people get displaced and thrown off from where they are, or where they are fenced off from the resources they can otherwise access. And there's a very useful, very instructive manual that was put out by this doctors group in Chhattisgarh, who looked at all the plants and the fruits and various kinds of things in that area, put a nutritional value to it, looked at the seasons when it is available, and said how many of those communities survive when in any other, in a situation where they are dislocated from those resources, they might just die of having nothing. And how do they survive, and what is the nutritional content, and how do they live in the midst of that? So what we then, in discussion with them, realized was that there is, when you fence them off, there is induced vulnerability, which is actually the third category. So there is poverty, there's impoverishment, and there is vulnerability. And vulnerability is not just a natural condition very often, it is induced by various processes. And that's central to understanding the socioeconomic status of tribal communities. I'll stop at that.
Thank you, Usha. Jackie?
I'd like to talk about land in South Africa. So obviously, in 1994, two issues came to play regarding land. The first was that 84% of land was owned by 15% of the population, being the white people in South Africa. Another issue is that you, like in India and in many settings, had at least two kinds of land management, or a legal category of land operating. The first was individual title, and the other one was communal use. So in the one, obviously, the issue is ownership, and in the other, it's occupation and use. So one of the major compromise and settlements of 1994 was around the issue of land, given this huge disparity between 84% of the land being owned by 15% of the population. I would argue very much that a lot of the failure of land restitution subsequently is really not related to the Constitution itself or the text, which, as I was saying yesterday, I believe genuinely would allow for radical change. I think it has been down to implementation, the government, and various other class alliances, but that not according to the text of the Constitution specifically. But Section 25 of the Constitution, which is the property clause, tries to do two things. It has a defensive or protective component, so that's sections 25(1) to 3, which effectively create the protective component. It freezes land as land distribution as it was in 1994, and it says that there will be no arbitrary deprivation of property, and it says that then it moves on to expropriation, that expropriation can only occur with compensation. Now, it is commonly believed in South Africa that compensation means market value. But in fact, the Constitution lists 5 considerations, which are the current use of the property, the history of the acquisition and use of the property, the market value of the property is only the third, the extent of direct state investment and subsidy in the acquisition of the land, and the purpose of the expropriation. Now, the thing about subsidy is an interesting one, because most white farmers in South Africa would have received substantial state subsidies in the apartheid regime, and that is meant to be subtracted from any compensation, but it simply never is. So those are the protective elements that you will not have your land if you had it prior to 1994. You will not have it arbitrarily deprived, and you will only have it expropriated according to pursuant to a law of general application in the public interest and with compensation. Now, land reform is one of the big programs of public interest and recognized as such, and this is where you get the redistributive clauses of Section 25. So it tries to do both of these things, protect past ownership, and also it does attempt to redistribute, to allow for redistribution. So Sections 25(5) to 8 compel the state to take all reasonable measures to promote access to land. And here comes in the issue of land restitution to people who were previously racially deprived of land pursuant to racial practices or laws. So this is the land restitution program. Just to say that obviously the issue of land and property in South Africa is highly racialized. In a recent survey of 3,700 people by Jim Gibson, he found that 85% of black respondents believe that land was previously taken illegitimately, compared with only 8% of white respondents felt that. Regarding redress, 68% of black respondents believe that land should be returned to previous owners no matter what, whereas 91% of white respondents disagreed. So, I mean, unsurprisingly, the haves completely disagree that they previously took the land illegitimately and that it should be given back to the have-nots. So restitution of land is, as I said, there inherent in sections 25, 4 or 5 to 8, and a big piece of legislation has been passed, the Restitution of Land Rights Act 22 of 1994, which was amended in 2014 to open the second phase of land restitution. So the purpose of the Restitution of Land Rights Act, it was supposed to serve two purposes. The one was, and by the way, there is a separate thing on land tenure reform. So in terms of Section 25, there is also a whole component that's not about ownership, but about land tenure reform. So that gave advanced rights to people who unlawfully occupy land, and also to people who, labor tenants, etc., who don't own land but have been living there for many years and also been giving their services of labor. But I'm now going to talk about the issue of restitution of land. So the Restitution of Land Rights Act, first of all, provided the cutoff date. Some of the controversial issues here at play are 1913. It's in the Constitution and in the Restitution of Land Rights Act. That is the cutoff date. Now, many people are concerned about that. What about colonial dispossession? But there, on the other side, there are reasons for this, and it's considered to be a huge can of worms. For example, there's a lot of tribal dispossession and repossession, etc., that occurred prior to 1913 that might be caught up in all of this. And for example, the Khoisan have got a land claim which currently wouldn't go anywhere because it's they were dispossessed way before 1913. They have a claim for the whole of South Africa. So in terms of the Restitution of Land Rights Act, you had a certain amount of time. It was originally until December 1998, a very short window to lay a claim for land that you were dispossessed of pursuant to racially discriminatory laws or practices. That has been reopened, as I said, in 2014. It's now been reopened for a second phase up until 2020. But you can claim either as a person or as a community who is dispossessed. There is a whole machinery around this. There's a Land Claims Commission, there's a Land Claims Court, and then any appeal from the Land Claims Court can go to the Supreme Court of Appeal and the Constitutional Court. It was supposed to be about restitution, but what has happened in reality, as very poignantly set out in a great book by Bernadette Atuaheni called We Want What's Ours, is that in fact the Land Claims Commission has been, for whatever reason, probably because they were understaffed and underfinanced and under pressure, they have effectively pushed not for restitution in most cases, but actually for what's called the standard settlement offer. So people who were dispossessed often when they were dispossessed, not of land ownership, because it was actually very hard for particularly Africans to own land, to have individual title. It was often in a communal arrangement. So that's the second problem and clash, that you have effectively an attempt now to try to evaluate what a communal land rights claim then would have been worth now. And this might be about labor tenancy, it might be about sharecropping rights, not about ownership per se. So that's one of the difficulties. And the Land Claims Commission, what it has tended to do is, instead of allow people to go down the very difficult and complex process of trying to restore land, and thereby also contribute to the purpose of redistribution, has actually just given people relatively small amounts of money. So the first clash that you see is this issue of how do you, in fact, restore what was lost all those many years ago? How do you give it a value, especially in a current context where kind of the market and private ownership seems to dominate, but what you lost was not that. So even for those people, the relatively few African people who had private title, and some Indian and colored people, I say Indian and colored because those are the other racial definitions in South Africa, even for those who had individual title, there have been huge problems to try to figure out how to give compensation. So what has happened in cases where subsequently the land has been developed? So, for example, you had your land dispossessed in 1956, and it was a piece of land in Cape Town that you perhaps had a small homestead on. Now today it is a parking lot and a shopping mall. What happens there? The Constitutional Court and all of the land claims machinery has said time and time again that in these cases it is not feasible, so they use feasible. It is not feasible to restore the land to the claimant. So then the question becomes, what about compensation? Now, in terms of the Restitution of Land Rights Act, you should get equitable redress if you cannot get restitution of the land. How do you work out what equitable redress is? So just quickly to talk about the sort of seminal, the most recent case from the Constitutional Court is a case called Florence of 2014. This is about a family exactly who lived in Rondebosch in Cape Town between 1952 and 1970. Mr. Florence contracted with the property owner, Mr. Yeller, to purchase the property in installments. He made the final payment of 46 Rand in October 1970. However, the government refused to transfer the land in terms of the property register because the land was under the Group Areas Act, not registered for colored people. The owner of the land, of course, what a bonus. He'd been receiving the money all the time. He agreed that, of course, the land should have been transferred, but couldn't because of the law. So as compensation to Mr. Florence, gave him 1,350 Rand and took back the house. It was common cause at the time that the property at that point was worth 32,000 Rand. So in 1995, as soon as he could, Mr. Florence, who was still alive, laid a claim in terms of the Restitution of Land Rights Act and Section 25 of the Constitution. And the Land Claims Court, the SCA, and the Constitutional Court majority judgment, and there are 5 different judgments in this case. You can see the judges were very conflicted about what to do. They all found that it was not feasible to restore the land because of it was effectively a parking lot, a shopping center, and a business now. So then they turned to the issue of equitable redress. Interestingly here, the most transformative judgment is by one of the white judges, Justice Froneman. He makes the point that, but this is a minority dissenting judgment, he makes the point that where restitution isn't feasible, you should come as close as possible in financial terms to the current market value. All of the other judges said, no, you don't. What you do is you take the market value at the time of the dispossession, 32,000 Rand. You subtract the compensation that you were given, 1,350 Rand. You times that by CPI to allow for changes over time, which the Act actually refers to. And there you get the amount that the person will be given. So in this case, that amount was 1,488 basically 1,500,000 rand. The problem is that the current market value of that property is 8 million. So herein lies the real issue. Is this equitable redress? And how should we be determining it? And I just want to leave with the counterpoint that, and this is the real injustice, that on the other side of the coin, and so that stands. So that majority judgment, although there are 5 other judgments in this case, the majority judgment there stands that the way you work it out is market value at the time minus any compensation times by CPI. On the other side of the coin, if I had a farm and now it is being expropriated pursuant to an accepted land claim, I am given market value now. So this is a serious contradiction and a serious injustice that is going on today in South Africa. I would say that this is not constitutionally driven, that market value is only one of 5 considerations, according to the Constitution. However, the government and the machinery around it, including the Constitutional Court, up until now, although in truth they haven't had a chance to really push the definition here in terms of how compensation should be determined, the government has effectively always gone for market value. So this creates this injustice. And then, just to leave with a final point, which is that in South Africa, as in many countries in the world, land is obviously an extremely emotive issue. But there are rising questions about all of this, the resource and all of the resources, all of the effort, even if people are given back, where they're given back land, what sort of value does it end up having in a country where effectively agriculture is being completely denuded, that unless you have a larger commercial operation, you're not able to really make it. The idea that land would in any way bring you out of poverty, etc., is increasingly being questioned. And so, yeah, let me leave it there. Thanks.
Thanks, Jackie. Dani?
So I'm going to speak about one case, but that I'm involved with at the moment, an eviction case. But in order to try to illustrate a much broader problem, and the broader problem, I think I can introduce by just reading from the heads of argument that we relied on in this case, my co-counsel Annemarie de Vos and I. And it reads as follows. It says, 2 diverse narratives go to make up this case. On the one hand is a white-owned company which regards itself as the undisputed holder of all the rights to the land, regardless of any other custom or right that may have been in existence long before it became the owner of the land. On the other hand is a family who believe that they rightfully live on the land in terms of their customs and traditions. They do not claim ownership of the land, but the right to live there in accordance with their customary practice. So the broad issue that I want to talk about is, the broad question I suppose I want to ask is, to what extent, in the context of access to land and perhaps property, to what extent can constitutional socio-economic rights address all of the diverse claims or all of the diverse problems that are associated with access to land in a post-colonial context. So in South Africa, access to land in the first place is obviously a practical problem. There are large numbers of people who do not have access to land or who live on land and do not have secure tenure to that land, so their occupation of the land is precarious. So that's one aspect that constitutional socio-economic rights should be able to address. A next layer is obviously the background to this precarious occupation of land and also to inadequate access to land more broadly is a history of conquest that also has to be addressed. So there's a broader justice question that has to be taken account of. But then even more broadly than that, land and access to land and that history of conquest is also a history of what Seppo refers to in his paper that we discussed yesterday, epistemicide. In other words, it is one manifestation of the replacement or the suppression of one worldview by another worldview, which is expressed in the displacement of one system of law by another system of law, a system of usage and practice, an occupation of land that is completely displaced by, in our context, the system of civil property law. So in very broad and grand terms, that's the problem I want to address on the basis of the particular case. So let me get to the case. It's the case of Bopape and the Merensky company. It's almost complete, this case now. We argued the case 3 weeks ago in the Land Claims Court in South Africa, and we're awaiting judgment. And the background to the case is the following. It's an eviction application that's brought by the Merensky company. Now, the Merensky company is a very well-known timber company in South Africa, a very large timber company in South Africa. But it is a particular kind of company. It's a company that prides itself on its corporate social responsibility, not only currently, but it's been in existence for a very long time. Also, all through apartheid, it's a company that prided itself on the manner in which it treated its workers, the manner in which it dealt with people living on its land. It provided very secure housing, for example, to all of its workers on its farms. It provided education to them and so forth. So it's not your archetypal evil capitalist devil. It's a company that at least presents itself in a certain acceptable manner. They own, in addition to about 70,000 hectares in the rest of South Africa, they own a group of farms in the northeast of South Africa. On this group of farms, they have a number of staff villages in which they're housed workers working on the farms. And in one of these staff villages live the Bopape family. So on the other side is the Bopape family, our clients in the case. And the Bopape family have lived as a family, not the particular people who live there now, but as a family, has lived in the area where they now live, which is an area of about 3 or 4 square kilometers that straddles 2 of the farms owned by the Merensky family, the Merensky company, for as long as I can remember, for generations. The earliest record of their occupation is in 1934, when the current father in the family was born. So we have this company that owns the land, and then the Bopape family, who say that they have lived there always, and particularly that they have lived there not only in terms of occupying the land, but they have lived there exercising what they see to be their custom and their practice, their way of life. They're quite particular about this. The Merensky company institutes an eviction application, brings an eviction application to evict the Bopape family. And the family had retired. He's since died also. So in the view of the Merensky company, as he's no longer employed by them, they are no longer required to give to him housing, and therefore wants to evict the family now. The family have no defense in law, in existing law, against this eviction application. The applicable legislation does not protect them. They do not have consent to be on the land any longer. The company followed the correct procedure. It terminated their right of residence on the property. So in terms of the existing law, they have no defense, and the eviction application should be granted. Yet they assert very consciously and very strongly the fact that they have exercised for a long time rights that are not recognized in terms of the civil property law over this land. So very clearly, this clash between one worldview embodied in a certain system of law, civil property law, and another worldview embodied in a practice that is not formalized in law, a custom that is not formalized into law, and that is also not recognized currently in terms of law comes to the fore in this case. So I'm going to explain how we argued the case eventually, and we don't know yet what the outcome is, and explain also why we argued the case in that way strategically, both in another and a broad sense, and then just leave the question to those in India and elsewhere that perhaps are faced with the same kinds of problems, this clash between different worldviews expressed in different bodies of law that apply to the same piece of land. Leave that out there so that we might get a response. So how we eventually approached the case was to say that in terms of the South African Constitution, common law, we have a mostly Roman Dutch-based common law, at least in the area of property. So it's judge-made law, that's our civil private law. Common law and customary law, or indigenous law, is regarded to be equal, have equal status at least. Both of them to the extent that they comply with the Constitution, consist with constitutional rights. So our approach in this case was to say, well, we must make that equality between common law and customary law operative in some way. So we cannot simply try to find, there also was no defense, but we cannot simply try to find a defense in the existing common law of property. We must in some way we must in some way argue for recognizing the customary law that was exercised here. So make operative the equal status of the customary law. So we delved into the common law of property, and we came across a Roman law, very seldom used, a Roman law mode of acquisition of property, referred to as, or named vetustas. So vetustas is a manner in which one can acquire a public servitude or establish a public servitude. A right of way is a good example. A public right of way is a good example. And you can establish through vetustas the existence of such a public servitude if you can show that the origin of the particular use of the land that is an issue is lost in the mists of time, is the phrase that is used. In other words, if there's no indication of an original agreement or any other form of actual acquisition of the right to use the land in that way, then a presumption is created that is rebuttable, but a presumption is created that that right was in fact established. So in this case, we argued, and we hope that it's accepted, that the manner in which the Bopape family used this land, their exercise of their family practice over generations, the origin of that is unknown, and therefore they have established a public servitude in favor of this particular family to continue using the land in this way. So we try in this way to insert into what is a civil common law mode of acquisition of property, figure in law, we try to insert as content the customary usage, the customary practice, to try in some way to incorporate this idea that access to land against the background of constitutional socioeconomic rights, a constitutional right to have access to land, that access to land does not only entail protecting tenure in some legally formal way or creating property, whatever else the case might be, so practically protecting access to land, but that there must be some recognition of this displacement of one worldview by another. So I would be interested to hear whether the same problem arises in other contexts and whether there are other ways in which to deal with it. In a context where the formal law, the constitutionally mandated legislation, provides no way to deal with this. So I think I'll leave it at that.
Thanks, Dani. Frank.
Okay. Is there actually some way to frame a single comment that will take in everything in these four rich presentations that we've had this morning? Probably not, but I'm going to give it a try, believe it or not. I'm going to try to offer, I've been scribbling it as I've been listening, a kind of schematic overview of all of it. And the headline, no surprise, would be something like the incredible complexity of the idea of property as a site of political contestation in a post-colonial context. It really is complicated. It involves property viewed under what I'll call an individual aspect, property viewed under a collective or community aspect. It involves conflicts within the individual aspect, conflicts within the collective aspect, and conflicts across the two aspects. So under the heading of the individual aspect, I'll distinguish between property as a human right and property as a constitutional right. Under the collective aspect, I'll offer property as social practice and property as development. And now I'm going to start trying to run through all of that. Property as a human right. If we think as an individual human right, if we think that access to and control over certain material means is prerequisite to individual human liberty and dignity, a liberal conception of a human right of property, then we're going to think that everybody ought to have it. And we're somewhere in the neighborhood of a socioeconomic rights conception of property. Property as a constitutional right is something a little different. Property as a constitutional right is the idea of limited government. It's the idea that the government doesn't take away from us what we have lawfully acquired or inherited or whatever. Property as a constitutional right in the sense in which I'm using the term is retention. But property as a human right is redistribution. And between redistribution and retention, there is an indissoluble kernel of conflict. I want to say that I entirely and completely agree with Jackie that there's nothing in the South African Constitution's provisions about property that should get in the way of the kind of redistribution to which the Constitution also is committed. But that doesn't mean that on an ideological level, that indissoluble kernel of tension between retention and redistribution does not remain, or that it is not politically very potent and continues to be politically very potent. So there's the nub of the conflict when we're dealing with property under the individual aspect, and it's been the main preoccupation for most of us lawyers and legal academics around the table. But we have Usha and Dani here. We have to think also about property under what I'm calling the collective or communal aspect. And there I will take first my category of property as social practice. The conflicts internal to that idea itself are now before us. In Jackie's terms, it's title versus practice. In Donnie's terms, it's civil law versus custom. And we're only on the verge, if even that, of trying seriously to address not only, right, the civil law custom conflict, but the relationship of that conflict to the individual aspect entirely. That is, it's not clear to me that our idea, our prevailing and normal idea of a socioeconomic right, which I think is an individualistic right, primarily in the way in which we discuss it, meshes with the communal, traditional, indigenous social practice notions that are part of the life of masses of the populations that our dealings have to assume responsibility for and responsiveness to. Then we have property as development. That's the state sovereignty aspect. That is, the state, as the patron of us all, assumes responsibility for direction of the major material resources within the boundaries of the state towards state, what shall I call this? State-collective purposes. Economic growth and development. In South Africa, the mineral, the mineral heritage, as the state likes to call it, of the country, is treated by the state in its legislation as possessory entitlement of the community represented by the state. That notion of property as development runs headlong into conflict with property as retention, and there's major litigation, and will continue to be major litigation in South Africa over the claims of mining corporations to full value compensation, what they calculate as full value compensation, for the state's assumption of custodianship on behalf of all the people over the mineral wealth of South Africa. So that's a development versus retention conflict. But development, of course, also comes into conflict of a major kind with property as a ground of identity, right? Traditional property, property as practice, property as entrenched social life. The state needs a dam to generate electricity for developmental purposes, and communal life as traditionally practiced or understood on the land is destroyed. Different aspect of development. The state needs to reclaim the city. It needs to reclaim the center city from blight, as we learned to call it in the United States in the 1960s and 1970s. Now, what is the blight? Is the blight physical? The fact that the quarters in which people are living are dilapidated and are fire-prone and are disease-ridden, or is the blight the occupants? Continuing major inflammatory political question. Property as development means replacing what's there and currently occupied by populations of cities with something new. Now, the something new might be housing. That is to say, the state might be wishing to evict current occupants so that it can proceed in a positive way to carry out its obligations under a socioeconomic guarantee. But there are people living there. I mean, this is just another way of illustrating the complexity of the conflicts that arise. In South Africa, the state may be able to accomplish an eviction, but it won't be able to accomplish an eviction under the existing doctrine of the Constitutional Court unless and until it arranges for a conversation, dealing, negotiation between the state authorities and the current occupants, which must issue in alternative accommodation for those who are displaced to be supplied by the state. That's been extended not only by the way to state-engineered evictions, but it covers private land ownership as well. Suppose you have you're a private landowner and you have a dwelling unit that's occupied by someone whose lease has run out. You had a contractual lease. There's nothing about traditional or customary occupation here. You have an occupant who's contractually illegal, who entered into the contract and who has now stayed beyond the term and is not paying any rent. The owner comes to court and wants an eviction. Under South African law, that eviction will not lawfully be obtainable without a court order, and the court will not be able to order the eviction until satisfied that alternative accommodation as being provided for the evictee. So the conflicts just run all over the place. We see them, right? That last one is a conflict between property as a human right, SER type property, and property as retention in the traditional way. We have across from the communal to the individual, the conflict between the state as developer or as agent of development and private owners of, say, mineral wealth, erstwhile private owners of mineral wealth. And as I've already suggested, even between, right, two progressive causes, two causes that would be identified as progressive. Regard for the indigenous, traditional, customary ways of accessing and using the land on the one hand, and individualistically oriented socioeconomic rights claims. There is a deep, I think, ideological discontinuity. Not necessarily a practical conflict, but an ideological discontinuity that will surface, it seems to me one can be pretty confident, will surface sooner or later in the form of a practical conflict that will go to court, which will have no competence whatsoever to resolve the conflict, but under our constitutional dispensations will be held responsible to do so and will be assigned authority for doing so. That's Donnie's, in a way, that's the kind of case that Donnie is dealing with. This case is going to be resolved by a civil court, for which Roman law, to which Roman law actually speaks. But does Roman law speak to all the parties in the case, or does it only speak to the lawyers and the judges? Okay.